Good morning, one and all present here. I welcome you all to the 99th webinar of the Saturday webinar series by Managed CIA. I'm Zenith, working as content developer at Managed CIA, talking about the Center for Innovation and Agripreneurship, the Center of Excellence hosted at the National Institute of Agriculture Extension Management. It's one of the leading agribusiness incubators in the country, and Managed CIA has till date mentored 503 entrepreneurs and incubated more than 310 startups from various focus areas of agriculture and allied sectors. The topic for today's session is intellectual property right for startups, and we have two speakers joining us today. Our first speaker for the day is Ms. Bindu Sharma. She is the founder and CEO of Origin IP Solutions. This firm is into providing IPR services to a wide range of companies from IT, software, electronics, engineering, pharmaceuticals, telemedicine, biotechnology, etc. She's also a visiting faculty at Global Institute of Intellectual Property. I request Ms. Bindu Sharma to take over the session.
Good morning, everyone, and thank you so much for giving me opportunity today to speak on intellectual property rights. So I would just share my screen.
Yeah, I have made you the presenter.
Yeah, it's already there, I guess.
Meanwhile, I request all the attendees to use chat box to address the question to the speakers.
Yeah,
we'll be taking up these during the Q&A round.
Yeah, so I will finish my presentation in around 20 minutes and 5 minutes probably will have for question answers, okay? So very good morning to all of you. So intellectual property rights today is an important subject. You see lots of initiatives from Government of India and Startup India, Innovate India. So that itself indicates that intellectual property rights is important subject for various reasons that, till the time you create something distinct in the market, there are lots of players already there. So till the time you have anything distinct, anything different, valuable, difficult to copy, you really find it very difficult to sustain in the market, and your product doesn't stand out in the crowd. So Albert Einstein said that true sign of intelligence is not knowledge but imagination. So this clearly indicates that knowledge is something which you know, but imagination is something which you can create. So knowledge can take you only from A to B, but imagination can take you anywhere, and imagination is the founding stone of creating intellectual property rights. And you see today lots of startups around doing so well, so most profitable and most valuable startups. Some of them, they are our customers also. Yulu Bikes, Swiggy, Misho, Ather, EV Bikes, House Choice, Zoom Car, Unacademy. And you see the market is today flooded with Mamaearth products. Every store and the series of products that they have released in due course of time is like phenomenal. So these are the startups doing very well, and all of these companies, they have one or the other distinct element, whether it's a business model or the products or the kind of unique services. And then once you create these kind of uniqueness in your business, it becomes very important to protect it, because if you do not protect it, then others can use or misuse it, and this will at the end of the day spoil your own business. So if you see, like, Swiggy, the business model is unique. At the same time, they have good value in terms of value of their brand name. And similarly, Ather also has its IP in the form of patents. Now, generally speaking, intellectual property is creation of mind. Anything which you can create using your mind is IP. So this IP can be of great variety. I must say, it could be invention, it could be a book, article, software, it could be design of a bottle. So depending upon the kind of IP that you have created, it should be registered. It's exactly the same way like you buy your new house or you buy your land of a piece of land, you have to register it to claim ownership over it. Similarly, in case of IP also, once you create it, it has value, then it should be registered. So there are offices delegated to undertake registration of such intellectual property. And we have 4 intellectual property offices in India. That is Delhi, Bombay, Chennai, and Kolkata. And we have additional office in Ahmedabad for design registration. So every form of IP has to fulfill some basic conditions based on which it is registered. So some of the reasons why you should register your IP, because many Indians still feel that if you have created something good, it should be useful to the society, and this comes from our deep root knowledge that we believe in. Vidya Dan is the greatest Dan, and we still believe it, and I respect that as well. But when it comes to business, you have to protect what you have created. Otherwise, you will see many of them replicating your product without your knowledge also. So, intellectual property protection provides you competitive edge in the market. So you can stand out, create, distinct products. And it is also good for, when you register your intellectual property, it's good for branding of your organization. Why branding? Because you can always, publicize that you have patent on this particular product. This is a patented product. You see that many companies, they use patent as a marketing tool. Even though product is not very great, they just file patent application for it so that, in the advertisements, customer presentation, in front of investors, they can say that this product is patented, and this definitely brings more trust and goodwill from the consumer. And your IP can generate revenue for you in due course of time when such IP is commercialized. And for the startups, investment becomes easy when you have IP in place, because your investors, they want only to invest in the product or your company when they know that you have a product which cannot be copied by others, and it will sustain in the market for a couple of years. So if you're looking for investment, you definitely need to have a strong form of IP. And once your IP is registered, or it is at least filed for, talking to people becomes easy because you already have blocked a date and time for your IP. So disclosure becomes less risky after your IP is at least filed, if not granted. Because if my patent is filed yesterday, then my rights on my invention start from yesterday itself. And after that, even if I disclose it to you, you copy also, then also, I can stop you from copying my invention. So disclosure becomes less risky when your IP is at least filed. Now, there are various kinds of intellectual properties, like patent is the most talked about form of intellectual property. And patent is granted for the invention, and invention could be either a product or a process. Life of a patent is 20 years. So if you have filed for a patent in India, it expires exactly after expiry of 20 years. And patent rights are country wise. So if you have a US patent, that will be valid only in US. And if it is Indian patent, then it is valid only in India. So there are lots of misconceptions in the market that, US patent is valid in multiple countries, but it is not so. US patent is valid only in the US. Then comes trademark, which again is very, very valuable form of intellectual property for your business. So trademark is name of your business. It includes logo, tagline, and and the name itself. So trademark also should be coined very carefully, because if your trademark is similar to something which is already existing, then you may have lots of objections during the grant of trademark, and you may be refused also. And if your mark is similar to some existing big marks, then you may expect legal notices from various companies. So to coin a right trademark is very important. Your mark has to be distinct, and it should not be similar to something which is already existing in the market. Then comes copyright, which is granted for your software, mainly software code and UI sometimes. But copyright is important when you have more of software related products. Then comes trade secret. Trade secret is a kind of IP which is not registered. So if I have a secret recipe, for example, KFC case, so if I have a secret masala to make chicken more tasty, then I don't need to disclose that formula to anyone. So as long as I can maintain secrecy of my formula, then till that particular period of time, I have a trade secret. But the moment that formula is out, I don't own any IP because my IP is already in the market. So trade secret is a kind of IP which every business has, but they fail to realize that they have some IP, and trade secret is protected only by maintaining secrecy of it. Then is design. It is a kind of IP which is granted only for aesthetic look of the product, nothing to do with functionality, but aesthetic look of the product. GI or geographical indication is a kind of right which is granted to specialty of the place. For example, there are maximum GIs registered in the name of Karnataka. And to name some of them, Mysore silk, then you have Nagpur oranges, Dharwad peda, um, then then Himachal shawls, Pashmina shawls. All these are specialty of different states of India, and they get registered as GI. And the traditional knowledge is your knowledge which remains in the community. Just to give you one example, we take ginger honey for throat problems. So that also is a kind of traditional knowledge. So any knowledge which remains in the community since generations is called as traditional knowledge. Now, patent is the most talked about form of IP, and the word patent means disclosure. So when you draft and file a patent, that means that you have to disclose your invention to the government, and they scrutinize it, compare it with what others have already done. But still, if they find the product is novel, your invention is novel, they grant you right for 20 years. And after 20 years, your rights expire, and anyone can use your patent without your permission after expiry. As long as your patent is in force, your permission is required to use your patented invention. And as I told you that patent rights are territorial, your Indian patent is valid only in India. If you want to have rights in US, then you have to file US patent separately. Now, there are three requirements to get a patent. One is novelty, second is inventive step, and third is industrial use. So novelty is the first and foremost requirement. So novelty should be checked by comparing your invention with the existing knowledge, which is available in the form of articles as well as patents. So basically, patent search has to be performed before you decide to go for patent. So this example I've given here is Life Saving Dot. It's a very beautiful product, so I thought I'll share it with you. So, iodine is one of the important micronutrient required in the body, and women have been found to be deficient in iodine. Now, there could be mm, lots of ways how the iodine deficiency can be fulfilled. Like there could be injections, there could be a tablet, but this unique product comes with the bindi, life-saving dot. It is called as bindi. So this bindi has a layer of iodine. So if a woman wears this bindi for a particular period of time, then the daily requirement of iodine is taken care of. So this I feel is a very beautiful a product, and it's basically, technically speaking, it's nothing but it's a patch in the form of bindi. So every woman is comfortable wearing this bindi. So there is a video, but I can share it with you, but time is not enough. So I'm skipping this. If anyone wants to see this video, I can send separately. Okay, so if you plan to file for a patent, then documentation of invention right in the beginning is very important. So if you are a company, then you need to have right policies and processes within the company to have a conducive environment to, convert your ideas into inventions, and defining ownership is very important in whose name patent has to be filed. And till the time your application is filed, I highly recommend that you should have strict confidentiality of the invention maintained within the organization. So documentation, after documentation is done, first of all, just check whether your invention is novel or somebody else has already done, because this is the first and foremost important point when you decide to go for a patent, that check for novelty of it. And after that, you file your Indian application. And if you want to go for any kind of foreign filing, then you have time of 12 months from your Indian filing date. Okay, so within 12 months from your Indian application, you can file in any foreign country where you want to, file. So if the patented invention is, required in the market and consumer needs it, then it can really be commercialized very well. I just give example of, during COVID time, Indian Institute of Science, the professor Praveen Ramurthy, Dr. Praveen Ramurthy, this is Material Science Department. So he created oxygen concentrate, and this oxygen concentrate has now been licensed to 30 plus companies. So this was a very successful product, and this was launched right in time and very easy to use. And this is how, if you create an invention which is required in the market and people need it and it is launched at the right time, you can commercialize it really well. So how you can start with the process of IP? Let me just explain it to you. First of all, when you start the process of IP, perform internal IP audit, just to find out what all you have, what all segments you have, what all new products you have. Then you analyze each and every idea, product, technologies that you have, and shortlist some of them for IP filing. I know you should not be filing IP for each and everything that you have, because every filing is going to cost you. So you should select only the good ones which are important for your business. And after that, I think understanding customer needs is extremely important. But till the time your product does not meet market needs, it will, even though product is good, it will never be a successful product in the market. I just gave example of this. This is a restaurant, Taza Tindi in JP Nagar, Bangalore. So you see, there are lots of fast food eating joints, but this comes with a difference that as soon as you enter, they have a UV plant wherein you can see how the plates are washed and how the cleanliness is maintained, what kind of water is used. So it is, as a consumer, you see how hygienically food is prepared, then all your utensils are washed in hot water, and then they undergo UV sensitization. Then it is very satisfying for the customer. So they have identified this one customer pain, that hygiene. And that's why any time of the day you go there, you'll find lots of people sitting outside. Inside it's full. And when you try something new, validation in the form of small sample size is important before you launch your product full-fledged in the market. So trying your product with small sample size is extremely important. So Oreo released a product, watermelon biscuits. They tried a small sample size, it failed drastically, and they discontinued from the market. And same is the case with the e-cigarette and Samsung one. There was one specific model of Samsung Note where it caught fire, and then it was discontinued from the market. And then IP protection is important. Now you know that you have met customers' requirement, product is good, novelty search is performed, but you must protect it. Parle is one company that lost rights on the word gluco. Earlier it was Parle Gluco, but they did not file their trademark in time. And later on, lots of companies, they started coming with the word gluco, and Parle Gluco lost rights on the word gluco, and then Parle Gluco was changed to Parle G. So this is what happens if you don't register your IP well in time. Then you may have to lose rights over your IP. Now, if everything is set, you are making good profit, business is going well, IP is in place, but still your product should have continuous improvement. You should keep making effort to improve it completely. Bata is a revolutionary brand now. The kind of designs they had now and the kind of designs they have earlier, there is a huge difference. So Bata has drastically changed its design. Then Cadbury's, if you see, earlier it was like we always believed that chocolate is to be eaten by kids, but Cadbury's kept on improving the product to the extent that they overcome that phase when there were worms found in Cadbury's chocolate. They worked extensively on the packaging technology, and they also, Meetha Ho Jaye was one campaign wherein we now believe that chocolate is something which is to be eaten by each and everyone, irrespective of the age. So that's how they not only increase their customer size with one single campaign, that Meetha Ho Jaye. So now not only the kids, but elders, every age group tried Cadbury's. Adoption is the key. Now, even though you have a breakthrough product, you should not miss out the point how the market is changing and what kind of evolution or adoption is required in the market. So Nokia is one example. Nokia did not realize that the world is going towards Android. And slowly and steadily, Nokia, which was the biggest brand in telecommunication, got just washed out from the market. And same was the case with Kodak. Kodak also was washed out from the market just because Kodak did not realize how the market is going to switch over to a digital photography. Okay, so adoption, understanding how the market is evolving is extremely important for any kind of business. So I'll just conclude. So what all you need in your organization to create a culture of innovation? You should have right policies, right processes, your employment agreements, your NDAs, they should all talk about IP. Who is going to own that IP, whether employees will own, you as a company will own. So you should have right policy with your vendors, customers, employees, whosoever is associated with you. Customer needs have to identify it, and you need to create a pipeline of ideas, and so that you can select the good ideas from the pipeline of ideas. IP protection is important. Once you protect your IP, you should validate it, run a pilot project, and then you should go with improvement and scalability of the product. So we as Origin, we are IP and legal service providing company. So we are performing complementary IP audit for some companies. So there is a form which is to be filled. So in case you are interested in getting complementary IP audit done, then you can always fill this form. I will probably share in the chat box, and we will select only five companies for complimentary IP audit in the month of September, and the last date to send your nomination is 9 September 2022. So by doing this IP audit, we will help you identify what is potential IP you have. We'll guide you how you can protect it, and we will also provide you complete roadmap which is in sync with your business goals to effective IP protection and exploitation. We provide services in the area of IP protection, enforcement, and IP commercialization. And prime areas of focus that we have is patent, trademark, copyright, design, and we draft all kinds of legal agreements. Okay, so if you have any questions, maybe we can take some of them. It's a chat box. Okay.
Yes, ma'am. Typically we take question and answer once both the speakers are completed.
Okay, fine.
Give us 10-15 more minutes. We have a startup here with us. She will be sharing. She's a patented startup.
No problem.
We'll take last 20 minutes. We'll cover the Q&A, curated Q&A as well as direct Q&A.
No issues at all. And thank you so much for your patience hearing. And I think I finished well in time, 11:24.
Yes, thank you very much covering exhaustively in the given time. A lot of information to process probably for our attendees. We'll get back to you with question and answer. On this note, we thank Bindu ma'am and we welcome our next speaker for today. We have Sudha Ramesh Karbari, one of our incubators under RKVY-RAFTAAR program. She has an innovative solution for solving the problems, which is a patented technology for soil testing. I would welcome Sudha ma'am to share her experiences and the process of filing, what experience she is having, how much time it took, the journey. Ma'am, welcome you, ma'am. Please, over to you.
Yeah. Thank you. Thank you so much for giving me the platform as well, so that I can share what I have gained through the support of Government of India and my patent attorney. Hope the session might be useful to everybody. So, good morning, everybody. I'm Sudha. So last year we founded Arkash and Innovations Private Limited. So we were very much enthused towards, I'm a researcher turned entrepreneur. So we always wanted to do innovation. So that's how I thought, let me put up my expertise into doing something which can be useful for the society. So initially I had a lot of ideas, like we can do nano pesticides, soil testing devices, and nano pheromones and all that. So initially when we started off, we were approached by investors based on my expertise itself. But the way it went, I was like very not open towards disclosing whatever I had in my mind, because I was just then startup, and if I tell the ideas as of now, then what shall be the consequences? That were my initial thoughts. So what did I do? Maybe after just maybe March, we started off. Other 2 months, I just looked around what can be done with respect to my ideas. Can that be patented? Yes, ideas can be patented. So we started off with doing some 3D models, designs, and then checked out for the patent search. And then I came across something called as ipindia.gov.in /sipp.html. That site I had visited. So it's a specific scheme for facilitating startups intellectual property protection, SIPP scheme. So this is valid as per the Indian Startup India portal, if you have all been aware of that. So if you are a startup and formed within, registered within 6 years or the stipulated time what they have, and your revenue is not like too much of generation and you're not into commercialization stage, you can utilize this scheme. So that's how I went and searched what is all the site about. Then I was fortunate enough to find out one of the PDF which tells me about, like, there are patent facilitators, because I had a past experience of filing a patent as an individual, but not as a startup, because I started later after that. So it costed me somewhere around 75 to maybe 90,000, the complete cost only for filing. And still that is in the, it has not even crossed the publication stage. There are three stages for any patent. One is you have to file. After filing, it will get published. It is open for a common person to oppose, like, okay, this is exclusively not innovative, and we also having something like that. So it's not yet published, but through Startup India thing and through this SIPP thing, we are able to have one grant and file 6 patents. So I'll just tell the procedure what I have followed, so that maybe even most of you may be able to relate what I have been what was my journey from the point where I started filing the patent till the point where I got a grant. And this happened within a span of, I think, 5 months. So it was one of the fastest that I could get. So I went to the site of SIPP. I found the patent facilitators. Before I found the patent facilitators, I mailed them. I selected few of them which were near to my place where I was staying. So I mailed them a query that I'm a startup and I want to apply, and how is this procedure? Because some guidelines were there, but still I was not very clear how is this whole thing all about. So they told me and they explained it to me that this is something like the patent facilitator fees shall be borne by the Government of India, and only the registration, the filing, the examination, the publication charges has to be paid by the startup, and that too very deducted amount. If for early publication some 12,000 is there, we only have to pay 2,500. So that was a very, that's how, because of this cost being reduced by the Government of India, I was able to file so many patents, and the process happened very, very fast. So I sent a mail to them and they replied it to me. Then I didn't go suddenly telling completely what I have an idea, because I was aware that I have to sign an NDA, which is something called as non-disclosure agreement. So whenever you have not filed a patent and you are talking to somebody else about your idea, just be careful. You make sure that you have a non-disclosure agreement. It is like two parties telling that whatever we discuss about this idea shall remain within us, and it shall not be disclosed by the to the third party. So that's how luckily I found one of the patent attorney who educated me all of this. We signed an NDA, non-disclosure agreement, and then we started with something called as IDF, which is Invention Disclosure Form. So that was the first form that he had sent me. And after that, he told me you should even have the DPIIT number. So but at that time, I didn't had what is the DPIIT number, Department of uh, Trade, something is there. So that we can check it out. So through that DPIIT, I just wrote it to Startup India team, and within a week, they were able to provide me with a number. And so that number we have to submit when I'm processing my patent application with the patent attorney. So that's how we started. And once I gave my IDF, so IDF is the first document that you give your invention. You're disclosing your invention in writing, not as a verbal conversation, but in terms of writing. Everything we put it down, every point we put it down. It came somewhere around, I think, 40 pages. And whatever images, whatever modeling I had done, that also I had disclosed in that. So you are supposed to disclose everything. You need not restrain something to yourself. So whatever you have with respect, whatever information you have with respect to that invention, whatever you're trying to protect, so everything needs to be given out. So I found this very useful, and it is not usually a patent is a techno legal document. I mean, it will not be completely technical. An individual also can file a patent in order to save the cost, but however the government of India is paying for the facilitator. So I thought, let not why not use this opportunity and the platform rightly, so that I save my time and invest this time itself in making the product than sitting and just filing the patents myself. So that was a very good decision made at a very early stage by us. And then we had submitted IDF, and it took 3 to 4 months for him to come back. Usually that time is required. You may think it is very long, but I think every word of it, my attorney wrote it in a different way. It was a completely, I mean, the content was same. Whatever I wanted to convey it was same, but in a legal kind of format it was. So I found it very useful. And that's how he sent me a draft after like 3 to 4 weeks. And the draft was also in such a form that there were a comment section where he was posing some questions whether this is right. He's clarifying, because now it is not like any research article that we write. It is something called as techno legal document. So that's how he gave me a place where I can just put my answers there. And that was our first draft, and it was everything was handled in a very professional way. So I mailed it back to him. He made some changes, and like this kind of conversation over the mails and exchange of information, what is right and what is wrong, happened like over like 1 month again. So we were about to get now the final draft, which was going for filing. So once we got to that stage, he gave me some more forms, which is like form 1, form 2, form 3, form 5, and power of attorney form, and drawings, because drawings are given specifically separate. And one more thing, what varied from other applications is my application and my claims were a lot more. Usually for any patent application, the charges are for filing, only for filing, it is rupees 1600, and you can go up till 30 pages with 10 claims. But mine was exceeding this amount. I had lot many claims, I think more than 10, and for every claim it is a charge. After 10 it is like 320 rupees you have to pay extra for that claim, and every page after 30 will cost you some 160 rupees. So overall, only for me to file it took 2800. But if it would have gone as an individual, so whole of the patent is filed under Arkashine Innovations Private Limited. So the Arkashine Innovations Private Limited is an applicant here, and I am an inventor. And if I had a team around working at that moment of time, yes, I have to include their names as well. But you do have interns along with working with you, then you're not bound to take the interns because they are not completely an employee. And that can be looked after. Maybe that we can later discuss how an intern comes into the picture, and an invention or an innovator, how can he be entitled as. So once we have done that, we filed somewhere in the month of June and 25th of June. So as soon as we filed, we got a application, I mean the receipt along with the number, some 12 to 14 digit number we had got. So that's how the patent has got filed, and so date was mentioned. So I was very happy that at least I'll be able to protect what, because the steps were inventive. The way I was doing the soil test, the USP was just you drop in the soil and you get the results out. There was innovation in 2 to 3 places. One, the procedure, how it moved from the raw form to a form where it can be testable liquid form. And then the testing happens in a different chip, and that chip also was innovative in nature, the way it is electrodeless. That's what we had claimed there. So your first claim, whatever claims we had, I think they were more than 10, 15 I had. So the first claim is very important. That tells you about, that's a independent claim. That first claim is an independent claim. Whatever comes after that becomes an dependent on your first claim. So we were very particular. I had a lot of questions. I have asked my patent owner. He was patient enough to answer my questions as well. In a layman language, it was like, what is a patent? Because I didn't start with that, but just I would like to tell that what's a patent. So it's something we can think of a virtual land kind of a thing. I mean, a virtual asset you have where you're not allowing any other person to encroach your property. Nobody can use what you have. It's like a kind of protection. You are stopping others from doing what you have or what you are doing. That's the whole thing. And being as a startup, for me, it was like I was putting my application everywhere. I was transferring my pitch decks everywhere. So it was very nice decision that I've taken. And the way Government of India and my patent attorney helped me, I was very confident at the initial stages, the way I was presenting. So that gave me a lot of confidence. So once we filed for a patent and we got a number, we didn't sit there. He educated me still on what are the next steps, because he sent me flowcharts, and I also just saw around some frequently asked questions which were into IP indiaoffice.gov.in. So based on the questions, frequently asked questions, and what answers they have given, I was able to figure out what is my next step that I have to do. So the next step obviously was, it is completely bifurcated into three steps. One is you have to file an application, then you have to go for publication. The third is you have to request for examination. It doesn't happen automatically. You have to send a request. I mean, it's a chargeable thing, and you have to initiate that process of examination. Once the examination happens, you are into something called as pre-grant stage. And if you are able to clear this examination state, your patent will be granted. So these are like raw way I have told, like 3 to 4 steps. But if you see the flowchart, it is very much detailed. So what we did is, within like 1 week after we got the number, we just sent for request for early examination. So once we sent for early, early publication, I'm sorry, we sent a request for early publication. Usually it takes 18 months if you are in a normal procedure as an individual, if you go, or even if as a startup you are going and you don't want to go for early publication, it takes 18 months. Till 18 months your files are disclosed, and after that it is taken up for the publication. But we want to fasten up this process, so what we have done is we filed within 1 week after we got the application number. So once we have gone for early publication, within 2 days it was onto the portal of Indian patents. I think everybody might have gone through searching how the Indian patents are given numbers and what and all is put up in the website. So I could see my publication with abstract and drawings and all the details within a week or so. Then after that we have asked for request for examination, and that also had a fee. So for early publication we paid around 2,500, and request for early expedited, that is what is called as expedited examination. Suppose you are not even asking for examination, the application will get abandoned. Even if you're going through a normal procedure, you will have to request for it. It doesn't happen automatically. So after that, after a week or something, we filed for even the examination, expedited examination. Within like 2 weeks, we got the first examination report from the patent office. So they had given some objections and prior art. Prior art, I think everybody knows. There are few steps that go into patent search as well, what the examiner does, because your patent is now being allotted to an examiner. He examines it, and if he finds some objections or oppositions or a prior art similar to what your work, he just claims like, okay, these are the things which are already existing. How do you justify, how do you clarify that yours is a novel? But we had got a first examination report telling that the steps were inventive. So that was a very relaxing for us. Only 2 to 3 query kind of a thing they had. Okay, this is the prior art already existing with respect to chip. Then how you just clarify this or just this? That was a in a legal way they had asked, not like what I am just telling. I was literally unable to even understand what the first examination report was concluding all about. And they had given us a 6 months period to respond to that FER. But still we went ahead and we had a discussions, and we went ahead within 20 days. We had, I think that thing came same thing. Like there was a Word document transfer between me and my attorney, and then we shared what is correct and what is not, how it becomes, how can we oppose their objections and so a lot of discussion happens and changes in the amendment because of such kind of justification that our patent is novel. So in just 20 days, we were able to even go for respond for this FER, first examination report. So by the end of September or so, we submitted. Then after 1.5 months, the reply came from the examiner telling like I wanted to have a telephonic interview. So that telephonic interview is not happening with me. It will happen with a patent attorney, because now it is like I have given a representation for my company or an individual, whatever it is. He is like a lawyer for you now. So what he's done is he went with a conversation call with him. He explained how was the invention different from the prior art, and that's how he. It's like a hearing, and you are objecting. Objections happens. So that's how he was able to do the telephonic, and maybe they were convinced like it's a novel thing, and that's how after that Jan 30th or something, we got a grant. So we started 25th of June and we got a grant. So a certificate is issued to you and it tells when when it will get expired. And for the first 2 years, we need not pay the renewal fee, but from the third year, every maintenance kind of a thing. So you will have to pay the amount, whatever prescribed as per the government. So I would like to just disclose out like how was the payment being made. So starting from, I mean, the application till the point I got a grant, I only spent something around 13,300, which was somewhere around 90,000. So that's a very good thing that I found. I would just want all the startups, whenever they are filing, they should be aware of what is something called as Form 1, Form 2, Form 3, Form 5, Form 28, Form 26, drawings, and all that. And officers, I think Madam had already told. Chennai, Mumbai, Kolkata, and Delhi for design, and even we have even 2 designs registered and 1 trademark in processing. But as this was only specific to patent kind of a thing and with a time limit, so I thought I'll only touch upon this and tell you what is this Form 1, Form 2, Form 3, just one line. So Form 1 is telling about what type of application it is and who is the applicant. Is it a startup or an established company or an individual or an organization like a college or something like that? Established corporation is big companies. Categories you have to define. There is a differentiation between applicant and inventors. That's how I told. I'm an inventor and my company will become an applicant. Title of the whole patent. He made it very generalized for us so that it doesn't come very easily onto the search. There are a lot of tactics that we do not know. So I was very lucky to get a patent only like that. So it is better for your company, you can have one. So that gives authorization details, patent agent, and then a kind of declaration in the last in the Form 1. So Form 2 is nothing but a complete specification, a techno-legal document, which I told, which came more than 30 pages for me. Title, application, field of invention, background, objective, summary, brief description, detailed description, claims lastly, and abstract in the last. And this abstract shall appear in the portal of Indian Patent Search, where your Form 3 is statement as undertaking, applicant name, his address, nationality, and sign of both the applicant and the authorized patent agent. Form 5 is declaration as to inventorship, a clear differentiation who is applicant and who is inventor. Whereas Form 8 talks about submitted like you are a small entity and you are giving out the DPIT details that you are a startup recognized by the government of India and this is the number. And we are into agri-tech domain, even that that certificate, whatever issued by government of India, DPIT number has that. And the lastly, it is a Form 26, which is a power of attorney. So all the proceedings shall be taken care by the attorney because we will be lost in our own startup, right? We are into more of product making and all that. So I found this very useful. So so we are assigning him like you take care of our proceedings, filings, prosecutions, any infringements, grant letters, ownership, restorations, filing and defending the opposition. So that's all I have to speak. If time permits, I shall talk something which any doubts if asked. I kind of. Yeah, thank you, sir. Sir, I'm unable to hear you.
So,
Sorry. Thank you for sharing your experiences, ma'am. I know there are a lot of technical things. So where you can, where some of them have questions where you can address them, ma'am. So not many people might be, having a core knowledge of all those things may take a lot of time to learn themselves, ma'am. What is your suggestion from your end?
Is it to me?
Yes, ma'am. Yes, ma'am.
Yeah, yeah. My suggestion as a startup, because I'm into multitasking and managing like with a team of very small team, so this had helped me a lot. Patent filing and the way the company has projected in the past 1.5 year. Now I can just tell I do have some 7 patents, 2 designs registered, 1 patent granted, and I'm working parallelly on multiple things just because everything is being protected. So that's my takeaway.
Okay, ma'am. Okay. Thank you very much. Ma'am, Bindu, ma'am, hope you are there.
Yes, I'm there.
Yes, ma'am. There are a couple of questions, very pertinent questions. So first thing, there is a notion that the IPR granting process in India is slow compared to other countries. What is your take on it, ma'am? Because some of the participants would like to know. So, is there any IPR official agency state-wise where they can approach for assistance?
Yeah, IPR filing and granting process was slow earlier, but now it's not slow. You can expect patents to be granted really fast, and there is a way where startup patents can be fast tracked. So you should avail that opportunity. And now grant of patents is very fast in India. So within 6 months, also there are some patents which have been granted. So I don't think this is the case now.
Okay, ma'am. Ma'am, trademark registration related one query is there.
Yeah.
Typically, how much does it cost and how much approximate charges for filing it? Are there any government subsidy or interventions in related to financial assistance are there?
For trademark, I'm not aware of any scheme. For patents, there are. And trademark, there is official fees, there is professional fees. So I think one trademark roughly should cost you some 20,000 rupees, all inclusive. Filing, then you will have a hearing. So 2025 is, I think, good budget you can allocate for trademark registration.
Okay, ma'am. Thank you, ma'am. There is a question related to the any state-wise assistance from government is there, ma'am.
So government, as Sudha Madam explained, there is assistance from the government, especially for the startups. So there are facilitators who file your application at nominal price. And apart from that, every state may have some scheme to get your money reimbursed. You need to just check what scheme is available in your state. But there are definitely, every state has some schemes where you can get your money reimbursed.
Okay, thank you, ma'am.
Yeah, sir, I would like to add a
Please,
point here.
please, ma'am.
Yeah. Already I got like so much of concession from Startup India thing, but minimum charges I had to pay. I mean, for filing the application, early examination, and expedited examination and early publication. So these were bifurcations for me. But even government of Karnataka is reimbursing all this amount, whatever I had spent,
Yeah.
like something 13,000 odd. But I didn't take up that because I thought I should not take completely free. I should also have my own little to be spent on. I will get a kind of ownership. So that's how I didn't take the reimbursement. But there are schemes. They are state-wise, not the nation-wise, state-wise.
Yeah, that's right. And most of the times the budget allocated is 2 lakh rupees for your Indian filing and around 10 lakh rupees for your international filing.
Okay, thank you very much, ma'am. Is there any specific protection for agri seed companies, ma'am? Is there any seed company related in agri sector, in IPR related, especially patent or
See, the seed as such, if you want to protect the seed, then I think there is good provision available in new plant variety registration in India. So, but otherwise, anything which is like related to seeds, patent will be difficult till the time it is a process to make a genetically modified seed or something. But otherwise, better way is to go for new plant variety protection.
Okay, thank you very much, ma'am. I would request any participant would like to ask question directly would raise your hand so that we can allow you to talk, ma'am. So one more thing, ma'am. Is there a place where we can search all the granted patents in India so far?
Yeah, there is a database maintained by Indian Patent Office. So you can see, you can just search Indian Patent Office, and there you see patent search tab, and you can search patents. But these are like the databases maintained by each and every patent office. But if you want a comprehensive overview, then you should go for some paid tools.
Okay, there are aggregator tools
Yeah,
there providing these
correct,
things probably.
correct.
Okay, will there be sector wise or all together it will be there?
Altogether.
Okay.
And you can do keyword search there and find out.
Okay, it's a single search per se. There is no
Absolutely.
dedicated focus area or vertical or nothing would be there.
Yeah, yeah.
Okay, great, man. Thank you very much. So, second. So Abdul Waziz is there. Jinath, please see if you can unmute him. And then we have Sudha Karan also.
Yeah,
Abdul sir,
this is Abdul Wajid. Just I would like to ask, maybe for a startup, now a lot of confusions are there. Which consultant or which advocate or attorney we need to hire for our process of patent, because they charge different fees. They also convince us they will do the patent within 3 months, 6 months, 1 month, like that they commit us. But we are in confusion to whom we have to trust.
Yeah.
And the fee, they charge the fees is also in huge amounts. So the government fees, as you have mentioned in the webinar, that is specific fees will be there. But we are in confusion how to hire or how to we need to have an agreement with the particular consultant or the for the patent related. Can you guide us?
I think this is a good question, and I have made one video on how to select your patent attorney. So I feel if somebody says that, I'll get you patent in 3 months, or I give you guarantee that you will get a patent, I think don't go with that patent agent. So you should check one thing in the patent agent, his technical domain. Ability to handle technology that you're talking about. So if it is agriculture, you should have your patent agent who come with biology background at least, and ask for the patents which have been drafted and by him or her, or they got granted also. See the track record. So fees is one thing, but I think don't go with any cheap person who says that I'll get to patent in 1 month. Okay, but go with the experienced person, because if the patent is not drafted properly, then even if you get it granted, it will not have any value, and it will not even be adding to anything towards the valuation of your company also. So it's not a asset at all. So go with the person who has technical knowledge. You can make out that in a 1 or 2 conversation how technically he understands your invention. And secondly, look for a person who is a registered patent agent. Ask for the registration number, and you can verify that number in Indian Patent Office website. So these are the things from my side. I think rest Sudha madam can tell better because she's on the other side. So
Yeah.
I may be
Yeah.
little biased,
So
but she will give you fair opinion.
yeah. Actually, even I did that way only. There is already a PDF that is updated every 6 months onto the portal of IP India. So there, the facilitators are verified by the government of India itself. And if you really don't find anybody, and it's not matching with your even technical details, and you have searched for 1 year and you're not even getting it, you please write it to them itself. So they will allot 3 best attorneys that can be provided with your domain. They will match. They will match with what you want to file a patent and what they have in with them, and they will give you 3 names. From that 3 names, you can just go and have a conversation and choose them. So what I have done is, as madam told, I have asked them what was their previous things that they have drafted. I got somebody from biochemistry. I got one person who was into software domain, and I came to know like I may not be very much compatible with this, because whatever I tell, they may not be able to grasp at least and draft, because the other person also should be knowing a little what your basic background has to be at least known.
Yeah,
So
I'm
that
just
I verified.
sharing video link. I found the video that I made, how to select your right law
Yeah.
firm. Tips to select right patent firm. I'm just sharing in the chat box.
That's great, ma'am. We are going to send the same thing with the mail to all our participants so that they'll be able to know also if somebody misses it. Thank you very much. One more question from the chat also was there, ma'am. So, what is the difference between filing a patent as an individual or filing a patent as a legal entity? So, what do you suggest in general?
In general, I suggest that if it is a company, it should be filed in the name of company. Otherwise, there is not much difference, in the sense that If you file in the name of company, it becomes asset of your company. You can show your expenses in your balance sheet. That becomes easier. Okay, but otherwise it's purely your choice, and in any time you can transfer from individual to company, company to individual. Not much of a difference. Only thing is your patent should be filed properly.
Thank you very much, ma'am.
I would like to add, sir, like
Please,
Please,
ma'am,
please.
please.
yeah. When we are an individual, I have seen my own friends, because when they have gone for investment rounds, there the investors have told to transfer whatever the individual patents they had, which are relatable to the company, to transfer in the company name. So it's a kind of better if you are having, if you are a startup. If not, you are not into that mode of startup thing, you can go for an individual thing. Yeah.
Yes, and we can say that it's suggested to go with the company when you want to commercialize it, because there are a lot of issues involved. But technically, there are no differences. That's what. So that's great, ma'am. One more question is
And
very
time, sir.
important. Yes, ma'am. Please.
And time actually, but when you go as an individual, for publication, you have lost 18 months just for publication. If you don't do it, like you don't want to go for early or something,
Okay.
18 months you have lost. And after 18 months for you to go for examination, it is like the time given is 48 months. So
So you
something
lost
like that.
major chunk of close to 40% you lost
Yeah.
there already.
Yeah. Timeline, I think, is a very important for taking decisions and bringing the product to market. So it's better you, that's what I had felt, and I would like to share this.
Sure. Thank you very much, ma'am. Thank you very much. So there is one more question related to, let me check. So Sudhakaran, we'll unmute Sudhakaran, Jinath. Sudhakaran, sir, please.
Yes. Yeah, I heard that if we are submitting MSME certificate for trademark, the government fee is 50% waived off. Is that right, madam? Now also it
Yeah.
is applicable?
Yes, definitely. It is.
Okay. Thank you, Jinath. We'll go to Indulkar, SP Indulkar. Indulkar, sir, can you hear us?
Yes, sir. Can you hear me,
Please,
sir?
sir. We can hear you, sir. Go ahead.
Yeah, it was a nice information in short time, madam. I would like to ask if patent is stopping others from what you are doing, then for allowing and promoting what you are doing, how will patent help? Hope I
Okay.
can make myself clear.
Okay, so patent will help you protect your work so that others cannot copy. But it's not a guarantee. It's just a tool that you can use whenever you want. But even if you have a patent, you will find some people using it without your permission. So, but at least if you have patent, you can stop them from using it. And then you can use it for branding. You can use it for valuation of your company, because every technology will have some value, and you will have you can use it for creating goodwill in the market, that so that your customers, your vendors, they have more trust in your technology, that it is patented. But otherwise it's a tool. It's not a guarantee that after you have a patent nobody will use it.
Thank you, ma'am.
Yes, sir.
So
Followed. If I don't have patent, then someone with patent will stop me. So it is better to have patent, so no one can stop me.
Yeah, exactly.
That is the advantage.
Absolutely.
Okay, so can we? Is it necessary to declare that I am not going to stop anyone while after getting the patent or something like that? Declaration is there, something at
No.
any stage, any form?
Not needed, but sometimes companies, they give patents in charity, and they say that 10 patents we are giving in charity, anyone can use it without our permission. So otherwise nothing required formally.
Thank you very much, ma'am. As we have come towards the end of the presentation, we would like to thank you both the speakers here, sharing their experiences and giving very valuable suggestions for our attendees here today. We have shared your contact details with our attendees here today in the chat. We are going to share them through mail also. They need any services or they need doubt, they need further clarifications, they'll be contacting me, ma'am. Hope we'll be obliging based on query basis, and it can be a business proposal also depending upon the requirement. Thank you very much. We would like to
Thank
thank
you so much.
all the speakers here today. I'd like to thank our Director General Manager, Director Dr. Sharan Raj, and our Center CEO. So we'd like to announce a couple of things before we wrap it up. The first thing, we have launched Agri Eureka, the challenge, innovation challenge and business plan challenge for ecosystem partners. It can be students, it can be startups, it can be R&D professionals. We have a problem solving solution for farming community or agri sector and allied sector. Kindly follow up with it. We are going to get a mail also with the link. It's there in the managed website and at CIA website also. So kindly go through it. And our team will be here to assist you how to participate in that. So the second thing is we are going to, we are touching 100 webinar next week. So
Very
we'll
nice.
be communicating that also, that it's a kind of a marathon, these things, despite we started due to COVID. However, we'd be able to continue that with the support of all our attendees. So we're going to get an update about that also for everybody. Thank you very much for being here. Due to the paucity of time, we could not address all the queries in who want to directly interact with the speakers. We try to address whatever is there in the chat. The personal interaction, whatever, you can take it forward with the contact details provided to you. Thank you very much. Have a great day ahead.
Thank you. Good day.
Thank you.
Thank you. Thank you.